stop everything you are doing right now. If you or someone you love is living in the United States on a visa, a green card, or any kind of immigration status, what I am about to share with you in the next few minutes could change everything. We are talking about rule changes that are already in effect in 2026, changes that are catching thousands of immigrants completely off guard, causing delays, denials, and in some cases, serious legal trouble. This is not something you can afford to ignore, not for one more day. Before we go any further, I need you to do one thing. Look at that subscribe button right now, not after the video, right now. Because the people who are subscribed to this channel are the ones who found out about these changes before they became a crisis. The people who were not subscribed are still sitting in confusion, spending thousands of dollars trying to fix problems that they could have avoided entirely. Which group do you want to be in? Subscribe now, turn on that bell icon, and let us make sure you are always one step ahead. This is US Visa Info, your #1 source for the latest and most accurate immigration updates. Today we are going to break down exactly what is changing for immigrants in 2026. We are talking about expanded travel restrictions, shorter work authorization periods, new biometric screening at the border, social media vetting for visa applicants, changes to the naturalization test, and a major pause on one of the most popular visa programs in the world. These are not rumors. These are official policy changes that are already happening right now. And if you do not know about them, you could face serious consequences. So stay with me from beginning to end, because every single section of this video matters for your immigration journey. Let us start with what is changing and when, because the dates here are critical. Starting January 1st, 2026, a new presidential proclamation expanded existing travel restrictions to cover a longer list of countries. This is not the old travel ban you might remember. This is bigger, broader, and it applies in ways that many people do not expect. The key thing you need to understand is this: it is not just about your passport. Officers are now authorized to consider your country of birth, your dual nationality, your history of long-term residence in a foreign country, and your recent travel history. Even if your current passport is from a country that is not on the restricted list, you could still face additional scrutiny at the border or at a consulate if any of those other factors apply to you. This is extremely time-sensitive information, and the sooner you understand it, the better prepared you will be. The countries facing a full suspension of entry include Afghanistan, Burkina Faso, Burma, Chad, the Republic of the Congo, Equatorial Guinea, Eritrea, Haiti, Iran, Laos, Libya, Mali, Niger, Sierra Leone, South Sudan, Syria, and Yemen. If you were born in any of these countries, or if you hold dual citizenship with any of these countries, your immigration benefits could be on hold right now. And I mean right now, effective January 1st, 2026, USCIS issued a policy memorandum directing officers to pause all pending immigration benefits for individuals born in or who are citizens of any of these countries. That means your OPT application, your work authorization renewal, your adjustment of status, your visa petition, all of it could be sitting in a queue with no movement while the vetting process takes place. There is also a second tier of countries facing partial restrictions. These include Angola, Nigeria, Senegal, Cuba, Venezuela, Ivory Coast, Dominica, Gabon, the Gambia, Malawi, Mauritania, Tanzania, Tonga, Zambia, and Zimbabwe, along with several others. For people from these countries, you may not face a complete denial, but you should expect enhanced vetting, reduced visa validity periods, and much longer wait times at consulates and ports of entry. Here is where it gets important. Before this change, a lot of people assumed that if their visa was approved or their case was filed, they were safe. That is no longer true. USCIS is actually going back and re-reviewing already approved immigration benefits for people from travel ban countries who entered the United States on or after January 20th, 2021. That means even if your green card was approved, even if your work authorization was issued, it could be subject to re-review. If you are from one of these countries, you need to speak with an immigration attorney right now. Do not wait. Quick question: are you subscribed yet? Because missing updates like this could literally cost you your green card. If you are watching this and you have not hit that subscribe button, do it right now. Every day this channel posts updates that could save you thousands of dollars in legal fees and prevent serious damage to your immigration case. Do not risk it. Subscribe and turn on notifications so you never miss another update like this one. Now let us talk about the social media vetting changes, because this one is affecting people who thought they had nothing to worry about. Starting in December 2025, the U.S. State Department expanded its online presence review requirement to include H-1B workers and their H-4 dependents. What does that mean in plain language? It means that when you apply for a visa, or when your employer files an H-1B petition for you, the government is now reviewing your social media accounts. They want your social media handles, your usernames, and here is the critical part. Your accounts must be set to public during the entire adjudication process. This used to apply mainly to student visa applicants, FM and J visa holders. Now it covers H-1B applicants and their dependents. And the vetting goes even deeper than just looking at your posts. USCIS has also launched a brand new USCIS Vetting Center, announced in December 2025, specifically designed to centralize this kind of enhanced screening. They are looking for ties to terrorist organizations. They are looking for what they call anti-American ideologies. They are looking at your consistency, meaning whether what you say in your visa application matches what you say publicly online. Here is what you need to understand about this. Do not try to hide things by making your accounts private or deleting posts. Officers will be able to see that you made changes, and that kind of behavior raises more red flags, not fewer. What you need to do instead is review your accounts for accuracy and consistency. Make sure your job history, your education, your professional claims online match exactly what is in your immigration filings. Even a small inconsistency between your LinkedIn profile and your visa petition can trigger a request for evidence or worse, an administrative hold on your case. Pay close attention to this part. USCIS policy now explicitly states that officers will consider whether an applicant has endorsed, promoted, supported, or espoused anti-American views or the views of any terrorist organization, including through social media. This applies to a wide range of applications, including OPT, STEM OPT, H-4 EADs, adjustment of status, extensions of status, and national interest waivers. If you have ever shared, liked, or commented on content that could be interpreted as supporting such organizations, even years ago, it could now be used against your immigration application. Let us move on to the changes that are hitting workers especially hard, and that is the new Employment Authorization Document rules. If you have an employment authorization document, you need to pay close attention. USCIS announced in December 2025 that it has reduced the maximum validity period for certain work authorization categories from 5 years down to 18 months. This is a massive change. Under the old rules, many people could get a work permit that lasted multiple years, giving them time to plan, to renew without stress, and to keep their employment stable. Now you have 18 months maximum for certain categories. What does this mean for you? It means renewals are going to come faster. It means the administrative burden is higher. And most critically, it means the risk of a gap in your work authorization goes up significantly. If your renewal is delayed, if there is a problem with your biometrics appointment, if there is an error on your application, you could find yourself without valid work authorization before your new EAD arrives. And if that happens, your employer may have to let you go to stay compliant with the law. This is why you need to start your EAD renewal process earlier than you ever have before. Do not wait until your current card is about to expire. Start at least 6 months in advance. Before we continue, let me tell you something important. Last year, thousands of immigrants missed critical deadlines and filing windows simply because they were not getting timely information. They were relying on word of mouth, on delayed news articles, or on advice from people who were not qualified to give it. The result was denials, fines, and in some cases, loss of status. You are watching this channel because you are smarter than that. But right now, the best thing you can do is subscribe and share this video with every immigrant you know. because the people who stay informed are the ones who stay in status. Now let us talk about what happens at the border, because the biometric screening changes are something every immigrant traveler needs to know before they get on a plane. A final rule took effect on December 26, 2025, expanding the biometric entry and exit program for the United States. Under this rule, Customs and Border Protection now has the authority to collect facial biometric data from all non-U.S. citizens at airports, land ports, seaports, and other points of departure. That means green card holders, H-1B workers, L-1 visa holders, TN workers, and everyone else who is not a U.S. citizen is now subject to this expanded biometric collection every time they enter or leave the country. Here is why this matters beyond just having your picture taken. The biometric data is linked to your entire immigration record. If there is any discrepancy between your travel documents, your visa records, and what is stored in CBP databases, it can trigger a referral to secondary inspection. And secondary inspection is not pleasant. It can mean being held at the airport for hours, missing connecting flights, having your employer notified of delays, and in serious cases, being denied entry to the United States even with a valid visa. Before any international travel in 2026, you need to verify that your passport, your visa stamp, and your immigration filings are all consistent and accurate. Let us talk about the documentation you need to have ready, because being prepared is the difference between a smooth re-entry and a nightmare at the border. When you travel internationally and return to the United States, bring copies of your most recent visa petition and approval notice, your most recent I-94 arrival departure record, your current employment authorization document if applicable, proof of your current employment such as a recent pay stub or a letter from your employer, your tax returns from the last 2 years, any pending or approved USCIS case receipts, and proof of your address in the United States. Keep digital copies on your phone and paper copies in your carry-on bag, not in your checked luggage. Officers have access to immigration databases, but they often ask for documents to verify what they are seeing on screen. The more organized you are, the faster and smoother your inspection will go. Now let us cover the diversity visa lottery situation, because this affects tens of thousands of families who were counting on it. On December 18, 2025, the Department of Homeland Security announced a pause on the DV-1 portion of the Diversity Immigrant Visa Program. The DV Lottery is the program that annually allocates up to 55,000 immigrant visas to people from countries with historically low rates of immigration to the United States. For many people, winning the DV Lottery was their only realistic path to a green card. And now that path is on hold. If you were selected in the DV 2026 lottery, your case may be delayed indefinitely. There has been no official timeline for when or whether the program will resume as normal. If you are getting value from this video, make sure you subscribe right now and turn on notifications. We post updates every single day on this channel covering the exact changes that affect your visa, your green card, and your ability to stay and work in the United States. This kind of information could save you thousands of dollars in legal fees. The subscribe button is right there. Use it. Let us talk about the naturalization test changes, because if you are on the path to citizenship, you need to know that the test has fundamentally changed. USCIS has implemented a revised naturalization civics test. The new test draws from a pool of 128 questions, up from the previous 100. During the actual interview, you will be asked 20 questions, and you need to answer 12 of them correctly to pass. Under the old test, you only needed to answer 6 out of 10 correctly. The passing threshold is now significantly higher. On top of that, USCIS has restored the practice of neighborhood investigations for naturalization applicants, where officers verify your residency, your moral character, and your attachment to the United States. This is not a small procedural change. It is a genuine increase in the standard you need to meet to become a citizen. Now, let us go through the specific action steps you need to take right now. This is your practical checklist, and I want you to follow it step by step. First, mark your calendar for your next visa expiration date and your work authorization expiration date. and count back 6 months from each one. That is when you need to start your renewal process. Not 3 months out, not 1 month out. 6 months. Second, go to your social media accounts today and review them for consistency with your immigration filings, your job title, your employer, your education, your timeline. It all needs to match. Third, if you are from any of the countries listed on the travel ban, contact an immigration attorney before you file any new applications and before you take any international travel. Do not assume your situation is unaffected. Fourth, make sure your address is current with USCIS. Biometrics appointment notices are sent by regular mail. If your address is outdated, you could miss an appointment, which could lead to a denial of your application. Fifth, gather all your immigration documents and keep them organized, both digitally and in hard copy. Do not wait until you need them to find out you cannot locate them. Let us talk about the common mistakes that are getting people into serious trouble right now. The first and most dangerous mistake is waiting until the last minute to file your renewals. With biometrics requirements, vetting delays, and processing backlogs, you can no longer assume a 90-day or 180-day processing time. Plan for delays and start early. The second mistake is deleting or hiding social media content before or during your immigration application process. Officers note when accounts go dark or content disappears. It raises red flags and suggests something to hide. The third mistake is traveling internationally without checking your visa status first. If you have a pending application, if you have had a recent status change, if your employer has filed a new petition, you need to understand what happens to your status when you leave the country before you get on that plane. The fourth mistake is assuming that an approved case means a settled case. Under the current policy, USCIS can and is reviewing previously approved benefits for people from certain countries. Do not assume you are safe just because something was approved in the past. The fifth mistake I see over and over again is relying on advice from friends, family members, or social media groups instead of consulting a licensed immigration attorney for your specific situation. Every immigration case is different. What worked for your friend may not apply to you, and bad advice in an immigration case can have consequences that last years. The sixth mistake is not documenting your physical presence in the United States properly. If you are a conditional resident or a naturalization applicant, you need to be able to prove where you were and when. Keep records of your travel, your rent payments, your utility bills, your tax filings. Do not make officers guess. Join our community of over 15,000 immigrants who stay informed every single day. Subscribe now and drop a comment below telling us where you are watching from and which of these changes affects you the most. Your questions and your stories help us create the content that this community needs. Hit that subscribe button and become part of a group that never gets caught off guard by immigration changes. Let us talk about what to expect in terms of timing, because the processing landscape in 2026 is genuinely unpredictable in ways it has not been before. Applications from individuals from travel ban countries are on an indefinite processing hold. There is no official estimate for how long that hold will last. For everyone else, expect processing times to be longer than the official estimates on the USCIS website suggest. The new vetting center, the expanded social media reviews, and the biometrics requirement are all adding time to standard adjudications. For work authorization renewals, plan for a minimum of 3 to 6 months and possibly longer. For adjustment of status applications, plan for significant delays if you are from any country that is currently subject to heightened scrutiny. For naturalization, the neighborhood investigation requirement will add time to your case, and you should expect that process to take longer than it would have 1 year ago. Best case scenario, if your documents are in order, your social media is clean, your case is straightforward, and you are not from a travel ban country, you can still get through the process relatively smoothly. But worst case scenario, a single inconsistency, a missed biometrics appointment, an outdated address on file with USCIS, or a social media post that raises questions, Any one of those things could stall your case for months or longer. This is why preparation is everything right now. Looking ahead, these changes are part of a broader trend that is not going away. The ESTA program for visa waiver travelers is about to face new data collection requirements, including disclosure of social media history going back multiple years. That rule has been proposed and is moving toward implementation. The H-1B selection process is also changing, with a new rule effective February 27, 2026, that changes how H-1B visas are awarded in a way that prioritizes higher-skilled and higher-paid applicants. If your employer is planning to file an H-1B petition for you, they need to understand the new selection criteria before they register. And public charge rules are also under review, which means the standards for who qualifies for immigration benefits based on financial self-sufficiency could change in the near future. In our next video, we are going to break down the new H-1B selection rule in detail, including exactly what it means for your chances of being selected in the upcoming H-1B cap season. That is a video you absolutely cannot afford to miss, so make sure you are subscribed so you get notified the moment it goes live. Let me leave you with the 3 most important things to take away from everything we covered today. Number 1, if you are from a country on the travel ban list, your immigration benefits may currently be on hold and you need to consult an immigration attorney before you take any action. Number 2, your social media is now part of your immigration file. Review it, make sure it is consistent with your applications, and do not delete anything. Number 3, start your renewals early. With EAD validity periods shortened to 18 months and processing times increasing, a gap in your work authorization is a real and present risk if you wait too long. The deadline pressure is real, the changes are already in effect, and the cost of not being prepared, in legal fees, in lost work authorization, in delayed green cards, can run into the tens of thousands of dollars. Please do not let that happen to you. Subscribe if you have not already. Share this video with every immigrant you know, every coworker, every family member, every friend who is navigating the United States immigration system right now. You could literally change the outcome of their case by sharing this information today. Stay informed, stay compliant, and remember, your dream is possible if you follow the rules. This is US Visa Info, keeping you updated every single day.